Welcome to our participants from around the globe to this webinar on World Heritage, Human Rights and Participation. A warm welcome to our esteemed panellists. We are grateful that you have taken up our invitation to participate in this important discussion that we're having today. In the lead up to the 50th anniversary of the adoption of the World Heritage Convention, the UNESCO Chair in International Law and Cultural Heritage at the University of Technology, Sydney, with our partners from the Our World Heritage Initiative, including Professor Meskel, Professor Liuzza, have been hosting a series of webinars on the theme of World Heritage and Human Rights. The videos of these webinars are available on the official UNESCO Chair website, and a link will be provided to the attendees after this event. Today's discussion on participation beyond states in World Heritage and heritage protection is an opportunity to review and reflect on the operation of the Convention and its governance framework within the broader developments in international law, particularly international human rights law, since 1972. Developments which are challenging established understandings of the objectives and functions of the World Heritage Framework and its role in the realisation of the mandate of UNESCO to further universal respect for justice, for rule of law, and for human rights and fundamental freedoms. Drawing on their work and contribution over decades at the international, regional, national, and local level, our three panellists will provide invaluable insights on defining and implementing participation by peoples, groups and individuals beyond states in decision-making processes concerning World Heritage and protected sites. Panellists will be presenting for 10 to 15 minutes. This will enable a period of Q&A at the end of the final panellist's presentation. Attendees are asked to pop questions they may have for the panellists in the Q&A function. These will be put to the panellists at the end of the last presentation. This webinar is being recorded and the recording will be made publicly available after this event. Now let me begin by introducing our first speaker, His Excellency Judge Abduljawi Ahmed Youssef, whom we are most fortunate to have join us today. Judge Youssef has been a judge on the International Court of Justice since 2009 and is president from 2018 to 2021. Before being elevated to the court, he was legal advisor to a number of United Nations bodies, including UNESCO. He has been an academic, founding the African Institute of International Law and founding and also general editor of the African Yearbook of International Law. His work and writings over many years, including as president and judge of the court, open a window into the broad concerns of this webinar and their perennial nature. His thoughtful intervention and leadership of the court in numerous contentious cases, including the Provisional Measures Order in Gambia and Myanmar of last year, and the advisory opinion in Chagos Island in 2019, and the Kosovo advisory opinion in 2010 covering the right of self-determination, have contributed to the elucidation, interpretation, and development of the rules and principles of international law, as is his stated aim. His understanding of the role of the court and the judges on it has opened up the court and international law in ways which can help us better address the pressing issues raised by our themes today. Welcome, Judge Youssef.
Thank you.
The floor is yours.
Thank you very much, Ana Filippa. I will address today, due to the limited time that we have, two aspects of the contribution of the court to the progressive development of the law on world cultural heritage and human rights. The first aspect concerns the conceptualization of cultural heritage in international law and how the court has laid down the conceptual and legal foundations for the international community to be able to elaborate the World Cultural Heritage Convention. The second point concerns how the court has contributed to the protection of certain vulnerable groups under international law, encompassing not only their intangible cultural heritage, such as language, religion, or traditions, but also cultural and religious monuments, historical archives, and tangible heritage. I will address the first question, because the first question actually was dealt with the court much before the World Cultural Heritage Convention was concluded in 1972. The first case or judgment in which the court addressed the issue of conventions which take into account common interest or common concern of humanity was the decision or the advisory opinion of the court in the case concerning reservationists to the Genocide Convention. This was the 1951 advisory opinion of the court. And the court pointed out that there are two types of conventions: apply or involve reciprocal exchanges among states, and conventions which are or correspond to the common interest and common concern of humanity. And the court described this latter convention as follows. It said, in such a convention, the contracting states do not have any interests of their own. They merely have one and all a common interest, namely the accomplishment of those high purposes which are the raison d'etre of the convention. This idea of civilizing conventions for the protection of a common interest to the benefit of humankind was already, therefore, beginning in the jurisprudence of the court. The second case in which the court contributed to the conceptualization of a convention that's concluded in the interest of humanity and because of a common concern of humanity as a whole, was the Barcelona traction case. And in the Barcelona traction case, the court acknowledged for the first time the existence in international law of certain obligations which are owed towards the international community as a whole. And the court described those obligations as follows, and I quote, "By their very nature, these obligations are the concern of all states. In view of the importance of the rights involved, rights which do not belong only to states, but also to persons and to peoples, all states can be held to have a legal interest in their protection. They are obligations erga omnes." So these two conceptualizations of conventions of common interest and common concern, which actually incorporate obligations and rights erga omnes, have laid the basis, in my view, in the conclusion of the World Heritage Convention. And you can find the same language both in the preamble and in the provisions of the World Heritage Convention. The convention, in its preamble, recognizes that the destruction of cultural and natural heritage constitutes a harmful impoverishment of the heritage of all the nations of the world, and that parts of the cultural or natural heritage are of outstanding interest and therefore need to be preserved as part of the world heritage of mankind as a whole. And then it continues In view of the magnitude and gravity of the new dangers threatening them, it is incumbent on the international community as a whole to participate in the protection of the cultural and natural heritage of outstanding universal value. So the evolution of the court's case law on this point can be illustrated in the manner which the court addressed cultural heritage in its two judgments in the Temple of Preah-Vihear. You may recall that the first case concerning the Temple of Preah-Vihear came before the court in 1959-1960. At that time, cultural heritage was treated as property, and the court looked at the temple as a property which had to be protected under the territorial sovereignty of the two states, of one of the two states, Cambodia and Thailand. And this was at the time in line with the thinking on World Heritage, because even in UNESCO itself, before the World Heritage Convention was concluded, the heritage was not considered as a heritage, but as property. So the court in 1960 ultimately found that the temple belonged to Cambodia, and as an ancillary matter, the court ordered Thailand to restore to Cambodia any sculptures, stelae, fragments of monuments, etc., that have been removed from the temple. But in its 2011 judgment on the interpretation of the earlier judgment concerning the temple, the court went much further, and the court recalled that under Article 6 of the World Heritage Convention, to which both states are parties, Cambodia and Thailand must cooperate between themselves and with the international community in the protection of the site as a world heritage, therefore underlining the erga omnes obligations which arise from the protection of cultural heritage. Now, to say a few words about the second aspect, which concerns the gradual recognition of the international community's interest in the preservation of people's cultural identities, traditions, and characteristics, I would like to recall two judgments of the court relating to genocide. The first judgment was the judgment concerning the case of the Bosnian genocide, the Bosnian genocide case. In that case, the court underlined that in its view, the destruction of historical, cultural, and religious heritage may not be considered to constitute a deliberate infliction of conditions of life calculated to bring about the physical destruction of the group. However, the court emphasized that where there is physical or biological destruction, there are often simultaneous attacks on the cultural and religious property and symbols of the targeted group as well, attacks which may legitimately be considered as an evidence of an intent to physically destroy the group. And that actually brings into focus the issue of cultural genocide, which was excluded originally from the coverage of the Convention on Genocide. The second point, which was also made by the court in the Croatia versus Serbia case, the court reaffirmed in that case and in its judgment that it may take account of attacks on cultural and religious property in order to establish an intent to destroy the group physically. Therefore, to conclude, because I think that I have almost, I am approaching 10, 15 minutes. To conclude, I would like to say that the court has progressively recognized the need for the protection of cultural heritage as an imperative value of the international community. While the court is a forum exclusively open to states, its judgments have transcended the boundaries of a strictly bilateralist legal order and acknowledged the interests of peoples and of the international community in preserving and protecting culture, not just as property, but as the world's heritage. So the protection of cultural heritage is not just limited to the protection of cultural sites of significant importance, but also to the protection of vulnerable groups, their social and cultural identity, and their intangible heritage. I thank you.
Thank you very much, Judge Youssef, and you picked up several of the themes that we had in our previous webinar a few weeks ago. So I thank you very, very much, both for your time and also your thoughtful intervention. Now, I'm happy to welcome Professor Francesco Francioni. Professor Francioni is an arbiter for the Permanent Court of Arbitration, a member of the Institut Droit International, and Professor Emeritus at the European University Institute and Luis Roma. He is the editor of the Oxford Commentary on the World Heritage Convention, which was first published in 2008, and which he is currently preparing a second edition of in time for the 50th anniversary of the convention. He has been a legal advisor to the Italian delegation, consultant to UNESCO, and also was president of the World Heritage Committee. In this latter role, he addressed concerns raised by the MIA, the traditional Aboriginal owners of the land on which the World Heritage listed Kakadu National Park is located. He also pushed to redefine the role of experts, and in these endeavours, he aligned the committee's work with contemporaneous developments in international law, particularly environmental law and human rights. Throughout, he has advocated for an expansive understanding and application of participation in World Heritage and protected sites as they affect the lives of people every day. Professor Francioni, welcome.
Thank you very much, Anna, and thanks for inviting me to this conversation, which gives me the pleasure to see and work with an old friend, George Youssef, whom I have known for many, many years, and with a new friend, Dali. You have actually recommended to me to start with a reflection on the trajectory that we can witness in the World Heritage Convention with regard to the issue of participation of state actors and human rights. And I will do it as briefly as I can in the 15 minutes that are allowed to us. Let me say, first of all, that I see two important points that coincide with my also participation in the work of the convention. The 2 points are the 1991 bombing of Dubrovnik in December of 1991, when I had the first opportunity to work with the World Heritage Convention, because I was asked by the Italian ambassador to provide some advice as to the ways to react to the outrageous attack on the old city of Dubrovnik. Now, in this case, we see that for the first time, we are departing from the rule of sovereignty as the dominating concept in the World Heritage Convention to a rule that it has been already mentioned by Judge Youssef. We are considering the common interest to protect an old treasure. And this was, of course, the first time in which the committee registered the a site in the World Heritage in danger without the consent of the territorial state. Well, the other turning point in the same period is 1992. And this was the time when the Director General of UNESCO established the center, the World Heritage Center. I happened to be present at the first meeting of the World Heritage Committee, in which this new structure was presented. And I remember that there were many oppositions on the part of the state parties to this initiative, thinking that it might have weakened the governmental control and the sovereignty of the member states with regard to the administration of World Heritage. It was very paradoxical that I was acting as a legal advisor to the Italian government, which together with the French government were the most opposed at that time to a World Heritage Center that might have developed new powers. So the fear was that there might have been a drift into privatization and the specialization at the scientific level of the World Heritage at the expense of the states. Now, eventually there was a compromise. The World Heritage Center has survived. It has worked very well with the help of the advisory bodies, ICOMOS, ICROM, and IUCN, has developed what I would call the knowledge of science, the knowledge of experts, rather than the knowledge of culture. That is different, and I will come back in a moment on this interaction between the two aspects. The relationship between human rights and world heritage, well, it is a complex relationship, and even here I see a very slow process of incorporating human rights considerations in the World Heritage Convention. It is clear that at the beginning, human rights were completely extraneous to the World Heritage Convention. In 1972, human rights had already become an important topic in international law. The United Nations had already developed a Bill of Rights with the two covenants on civil, political rights, and economic, social, and cultural rights. But the convention itself was not really inspired or conditioned by human rights. The first time that I see this dimension of human rights creeping in the work of the convention is with the introduction of cultural landscapes. The first time that this issue was addressed was when New Zealand proposed the inscription in the World Heritage of a mountain, Tongariro Mountain, a national park that had already been inscribed in the World Heritage as a natural treasure. But now, of course, there was the cultural aspect. That is, the mountain was associated with the spiritual beliefs of the Maori people of New Zealand, and it had an outstanding universal value as a human value, as a value connected to the culture, the religion, the beliefs, and the traditions of the Maori people. So in the Cartagena de India meeting of the World Heritage Committee, there were incredible oppositions to these ideas. I still remember many states just intervening to say, what are we talking about here? This is a mountain. This is cannot be just inscribed as a cultural treasure. And but unfortunately, this, of course, became very quickly a minority position, and the associated value of a physical space that has such a great importance for the spiritual life of the people prevailed. And then, of course, the human rights element was there. obviously, this case opened the path to the recognition of the intangible element of the living culture and related human rights of peoples and cultural communities as an integral part of the idea of World Heritage. Other aspects that I think are worth mentioning still is how the World Heritage has evolved beyond the expert, beyond the science, beyond the formally constructed type of protection that is typical of the Western approach to cultural heritage. That is by management plans, by regulatory plans, by the use of formal laws that have a strong positive law idea. And this was, again, in a case involving a site in the Pacific, the East Rennell case, where the people were the responsible agents for the maintenance of the value of this island. This island is the largest coral atoll in the world, and the UNESCO and the World Heritage Committee were confronted with a dilemma that there was no regulatory plan, no management plan in place, but nevertheless, there was a customary framework of management and property and ownership. And for the first time in this case, in 1998, the committee accepted the importance of the human type of tenure, the customary regulation of this park, of the island, and allowed the inscription on the basis of this intangible customary element. So this is, of course, another important aspect of the incorporation of human rights in the work of the World Heritage bodies. I would like to, of course, highlight that human rights in the context of World Heritage have a positive and also a negative role. They have a positive role when human rights are mutually supportive concepts. And this happens in the case of nominations and listing of cultural landscapes, as I have mentioned, and in all those cases in which the associative outstanding universal value derives from the link of the site with some human tragedies. Genocide in the case of Auschwitz, Goree Island in the case of slavery, the shameless practice of apartheid in the case of Robben Islands. So this is the case in which the human rights and cultural heritage, world heritage are in a synergic relationship, and they can support each other. The lack of due consideration of the human dimension of the world heritage and of human rights of the people inhabiting a nominated site can have also consequences in terms of conflicts about the proper management of a site following its inscription. This is the case of the Kakadu National Park, already mentioned by Anna in her introduction, where it was exactly the lack of consideration of the intangible element of the associated value of the peoples, the Aboriginal people of the area of Kakadu to the site that led to the controversial and very intractable case of the possible incompatibility of the decision of the Australian government to open a uranium mine in the area without the consent of the Mirarr people, who were the traditional owners of the land. the negative role of human rights in the relation to the World Heritage is much more problematic. It involves a reconsideration of standard processes of inscription and management of World Heritage sites by UNESCO and by member states. This, of course, involves the consideration of property rights on the land, of cultural rights of the local population, economic rights of the people relying on the natural resources on the proposed World Heritage Site. These are very important considerations. I remember when I was a president of the World Heritage, I would receive angry letters from people in the park in Peru, Chan Chan, who have been deprived after the inscription of their means of livelihood in using the natural resources. Even the International Court of Justice, Judge Yusuf is very much aware of this, has recognized the importance, the fundamental rights of the people who are relying for their livelihood on the resources of the land. And this was in the case of Costa Rica versus Nicaragua in 2009. So I think that I must come to the conclusion of my talk. I would like to say that the first conclusion I can draw is that the tendency of some states to treat the World Heritage cynically to foster nationalistic agenda and a predetermined national identity at the expense of minority. This is one of the great risks that I see, and unfortunately it is now a prevailing attitude on the part of many states. The second subject that needs to be mentioned is that not only states may be responsible for the infringement of human rights related to World Heritage. And we have seen that non-state actors, organized terrorism, and other violent movements and extremists have engaged in the wave of violent attacks against cultural heritage in Syria, in Iraq, in Mali, and other areas of the world. These attacks were directed not only to the stones, to the bricks or the marbles of the ancient monuments, they were parts of a perverse enterprise of massive human rights violations, persecutions of minorities, enslavement, rape of women, assassination of custodians of archaeological sites, and genocide. UNESCO, with its limited means and amid continuing political controversies, has had the merit not only of raising awareness of the importance of respecting culture as a condition for the respect of human dignity and human rights, but also starting a process in coordination with the UN of gradual integration of cultural heritage protection in peacekeeping, peace enforcement, and more generally in peace-building processes. Thank you.
Thank you very much, Professor Franchioni, for that wide and all-encompassing overview of the work of the committee and the importance of human rights in that work and the interaction with that. And welcome to Professor Dali Sambodora. Professor Dora is chairperson of the Inuit Second Polar Council, representing Inuit from Alaska, Canada, Greenland, and the Russian Far East. And he's also co-chair of the International Law Association's Committee on Implementation of the Rights of Indigenous Peoples. She's also senior scholar and special advisor on Arctic Indigenous peoples at the University of Alaska at Anchorage. We also thank her for coming so late. It's quite late there in Anchorage, so thank you very much, Professor Dora. She's involved in the negotiation. She was involved in the negotiations of the UN Declaration on the Rights of Indigenous Peoples for many years prior to its adoption by the General Assembly in 2007. She was the chairperson and expert member of the UN Permanent Forum on Indigenous Issues from 2011 to 2016, and the UN Voluntary Fund for Indigenous Peoples from 2009 to 2014. In these many roles, she has worked tirelessly for the articulation and effective realisation of Indigenous peoples' right to self-determination and participation in decision-making concerning culture in its many forms. Her intervention and influence has addressed the workings or otherwise of the World Heritage Framework on Indigenous and First Nations peoples worldwide. Professor Dora, thank you again for accepting our invitation and welcome.
Oh, I'm grateful for the invitation and pleased to join this panel with such esteemed personalities. And I've prepared some remarks in order to stay on focus with the commentary that I have about the World Heritage Convention and impacts upon Indigenous peoples. So on the 40th anniversary of the World Heritage Convention, I was engaged in an expert workshop involving Indigenous peoples from across the globe. Due to the injustices experienced by Indigenous peoples as a result of the convention, the results of that workshop are often referred to as the Copenhagen Call to Action. Today, my presentation will focus on the few strides that have been made, the persistent challenges, and a few recommendations to improve conditions for Indigenous peoples. Before doing so, it's important to share the framework that I employ for my present assessment. My framework is the trilogy of Indigenous-specific human rights instruments, namely the ILO Convention number 169, the UN Declaration on the Rights of Indigenous Peoples, and the American Declaration on the Rights of Indigenous Peoples. To be sure, these instruments have crystallized the distinct status, rights, and role of Indigenous peoples in the world community, as well as our universal perspectives. For example, like the nature of human rights, Indigenous peoples view the world in a holistic fashion. We recognize that everything is interrelated, interdependent, and indivisible. If one element or right is disturbed or interfered with, all other elements or rights are impacted. Article 3 of the UN Declaration affirms the right of self-determination of Indigenous peoples. The right of self-determination is recognized as the prerequisite for the exercise and enjoyment of all other human rights. And the right to free, prior, and informed consent is sourced in this right. Each instrument also affirms the rights of Indigenous peoples to lands, territories, and resources. These interrelated rights are essential to our identity, our lifeways, and our overall cultural integrity as distinct peoples. We consider ourselves to be an intimate part of the environment, and our survival and food security are tied to our respective ecosystems. However, both within and outside of UNESCO, many do not recognize the extraordinary legal effects of instruments like the UN Declaration. Therefore, it's important to briefly comment upon its legal status. Legal scholars and courts have acknowledged that though the whole of the UN Declaration is not legally binding, some of its key provisions constitute both general and customary international law and thereby create legally binding UN member state obligations in favor of Indigenous peoples. In this regard, the International Law Association has concluded that the UN Declaration articles affirming the right of self-determination, the right to culture, land rights, and the right to redress, reparations, and recourse are of a customary international law nature and again have corresponding legally binding obligations upon UN member states. So please remember this framework as I address the advances made as well as the persistent denial of Indigenous human rights in relation to the World Heritage Convention. It is laudable that a number of sites have been inscribed in a favorable fashion for some Indigenous peoples. 4 recent inscriptions feature significant and direct participation of Indigenous peoples and appear to have been driven by Indigenous aspirations. Specifically, the Pima Chiwin Aki designation in Canada more effectively aligns with Indigenous worldviews by embracing the interrelated elements of the natural world as well as the cultural values and identity of the Anishinaabe. They view this site as an important contribution to their own cultural integrity, but also as a gift to educate others. They state that this site is home to an intact boreal forest and an ancient culture that thrives today. Obviously, this is more than a World Heritage Site. The Indigenous peoples themselves physically, culturally, and spiritually manage the site, including the dimensions that support their sustainable hunting, fishing, and trapping. This more holistic approach is shared by Indigenous peoples globally. Likewise, with the Asuvisuit Nipissat, or the Inuit hunting ground between ice and sea in Greenland. It celebrates the profound relationship that Inuit have to their Arctic ecosystems. Immediately, the name of this site reveals the hunting, fishing, and harvesting activities central to survival for all Inuit. The ice and sea illustrate both ancient legends and the vitality of our present way of life. Here, it is worth noting that UNESCO refers to the interdependence between humans and their natural environment. The recent cultural landscape designation of the Budmi Bin, in fact, Anna, you'll help me pronounce this correctly, in Australia is significant because the site is Aboriginal owned and is managed to respect the customary and legal rights and obligations of the Gundit Mara traditional owners. The site includes an adaptive and participatory management framework of integrated customary, governance, legislative, and policy approaches. And through the direct involvement of Aboriginal peoples, it is inclusive of the natural values as well as the cultural values. Significantly, and as a matter of respect for and recognition of the Blackfeet, the Writing on Stone site in Canada was prepared by the government of Alberta in partnership with the Blackfoot Confederacy and with ongoing support from the government of Canada. The role of the First Nation representatives in collaboration with provincial and federal government representatives to recognize the area is an important sacred site. This is an example of good faith negotiations and genuine partnership. It also underscores the ability and capacity of the Blackfoot Confederacy to take action that ensures their physical and mental well-being. In addition to these more recent designations, the 2019 revisions to the operational guidelines make further reference to Indigenous peoples, human rights, and the right to free, prior, and informed consent. However, it must be noted that the language used is not obligatory, but more suggests optional behavior on the part of UN member states. This is in direct contrast to the solemn obligations of states under general and customary international law. Furthermore, without a strong emphasis on implementation of the treaty consistent with Indigenous human rights standards, and without oversight of actions, UN member states have far too much latitude. Another persistent problem is the politicized decision-making culture within the World Heritage Committee that Indigenous peoples have, I guess, evidence of. Any lobbying and horse trading based on UN member state self-interest rather than making decisions on the basis of genuine global values and Indigenous human rights standards is an affront to the purpose of the convention and perpetuates many of the human rights conditions that actually triggered the global Indigenous movement within the United Nations. An even more difficult challenge for Indigenous peoples is the hierarchy of heritage values created well before the negotiation and adoption of the human rights standards specific to Indigenous peoples. Presently, the World Heritage Convention silos natural values and cultural values, treating them separately. And this approach dismisses the holistic core of Indigenous peoples' worldviews and the diverse characteristics that make up our identity and ways of life. As such, an Indigenous definition of outstanding universal value and our cultural context has not been embraced. The result is protection of an area based on a narrow approach, which may ultimately threaten the actual value of a site, as well as ascribe precedence to weaken structural management schemes and values that do not align with those of Indigenous peoples. In contrast, the convention norms should be adjusted to embrace Indigenous values, customs, practices, and livelihoods surrounding a site, and be done so in collaboration with the Indigenous peoples concerned and reflected in the notion of outstanding universal value. The nature-culture divide, or the separation between cultural and natural values, continues to be a central problem for Indigenous peoples. The committee needs to put an end to the practice of labeling World Heritage Sites within Indigenous peoples' territories as purely natural sites. If sites are simply defined as wilderness areas, Indigenous peoples could end up being treated as threats to their own territories. Presently, the vast majority of Indigenous territories that are included on the World Heritage List are inscribed as natural sites, with no recognition of the Indigenous cultural values under the current notion of outstanding universal value. A pragmatic change would be to eliminate the nature-culture divide and facilitate the recognition of Indigenous peoples' relationships with the lands and the environment within the notion of outstanding universal value. In the Indigenous peoples' context, our human agency is a central part of the so-called natural criteria. Also, concerted effort should be made to align the management and governance frameworks of existing World Heritage Sites with the provisions of the UN Declaration. For example, Indigenous peoples must be fully involved in decision-making throughout such processes. The establishment of equitable and collaborative management frameworks and governance systems are necessary to ensure respect for Indigenous peoples and their livelihoods, including their land tenure systems and the profound relationship they have with their lands, territories, and resources. Such regimes should also include redress mechanisms. There are many World Heritage Sites where Indigenous peoples are excluded from decision-making and where egregious human rights violations against Indigenous peoples are commonplace. I understand that the nomination process of the Kang Krachan Forest Complex in Thailand has been accompanied by serious and ongoing human rights violations against the Karen peoples, including violent forced evictions, burning and destruction of homes and property, repeated attacks, harassment, and intimidation by conservation authorities, and even murder and enforced disappearance of Indigenous human rights defenders. Clearly, stronger efforts to remedy these conditions need to be made to ensure that Indigenous peoples are safe and that their personal security is not compromised in their efforts to exercise and demand respect for and recognition of their human rights. Based on the strong Indigenous human rights framework that has developed, there is a need to ensure that Indigenous peoples play an autonomous, independent role in designations that impact them and their lands, territories, and resources. A process needs to be established by which Indigenous peoples, by and for themselves, may directly advance their perspectives, understanding, and interpretation of how World Heritage Site nominations will impact them. Such a mechanism should be incorporated into the nomination process and become a formal part of the so-called completeness check by the World Heritage Center. In order to explore the most suitable way for accomplishing this, it would be useful to initiate an independent review led by Indigenous peoples in collaboration with others toward the objective of aligning the World Heritage Convention and associated processes with the weighty Indigenous human rights developments that have occurred. In conclusion, in order to respect and recognize the rights of Indigenous peoples within this far-reaching international convention, it is necessary to introduce relative equality, potentially through incorporation of the democratic principles of good governance. In this way, the world community can ensure that the convention is responsive to Indigenous peoples through their direct and effective participation in the work of the World Heritage Convention and its processes. Openness and transparency must become a cornerstone of all decisions and proceedings. The rule of law must be genuinely respected to ensure that actions are consistent with international Indigenous human rights standards, those that states and the UN system itself have obligated themselves to respect and recognize in relation to Indigenous peoples. Parties must commit to engagement in good faith and also recognize the progressive development of international human rights law, thereby displaying an openness to positive change. Such measures should become sustainable and durable elements of the World Heritage Convention. In conclusion, updating the convention and aligning it with current Indigenous human rights standards would demonstrate a greater respect for and recognition of Indigenous peoples and the cultural diversity that we contribute to humanity. We need to take serious account of the impacts of the World Heritage Convention through an intellectually honest assessment in order to right the wrongs that have occurred. Allow me to ask, when do we begin? Qianat, thank you.
Professor Dora, thank you for your presentation. I mentioned that you were tireless, and I wasn't kidding when I said that she started at 5 a.m. her time, and it's past midnight now, and your advocacy is extraordinary, and we're very privileged to have you today with us. Now I'll be able to open up the floor to questions from the attendees, which I've been gathering as our panelists were speaking. So I'll start with the first question, and this is to Professor Francioni. So there's a bit of rest for the other panelists at the moment. Professor Francioni, the question by Stephen Brown is, at what stage will we see the names of Indigenous peoples or First Nations on whose territories the World Heritage property exists being named or recognised in those listings in addition to the state party? So, for example, the site that Professor Dora mentioned, the Bujabim cultural landscape, mentioning the Gurudjamara and Australia together in that inscription process, recognising the First Nations on that World Heritage site. Professor Francioni?
Okay, well, it seems to me that from a technical point of view, the stage at which the rights of the Indigenous peoples, but also of other cultural communities and other peoples should be taken into account is already at the stage of the tentative list that every state is required to prepare before a formal nomination of a site is presented. So it is only at that stage that we can start identifying the outstanding universal value of the site, incorporating the human values wherever they are present, and avoiding the issue that I mentioned earlier that was that came up with Kakadu National Park, when even in the face of 3 different nominations, Kakadu had 3 different nominations. Then finally, even in the 3rd nomination, the Australian government had not been able to take notice of the important links that the park had with the thousands of years of tradition of the local Indigenous Aboriginal people, and the important cultural heritage that was linked to that area. So this is the source of a conflict later. So it seems to me that we need an ounce of prevention here so that we avoid the conflicts that come back then to haunt us at a later time when we have to manage a site that has been inscribed without the proper consideration of the human rights of the local population, and particularly of the indigenous peoples, because the indigenous people can claim a very special and decisive link with their ancestral land.
Thank you very much, Professor Francioni. And the next question is to Judge Youssef. The question by Judith Preston, Your Excellency, is, should Indigenous nations have standing in international courts and tribunals like the ICJ to protect their human rights as they relate to cultural heritage under international law when those rights are violated by states?
Thank you very much. As far as the ICJ is concerned, it is a court which deals exclusively with disputes between states. And it would be difficult to envisage that a dispute is between a state and the peoples who live in that state could be brought to such a court. Except, of course, if the rights of those peoples are endorsed by another state, and that other state brings it to the court, which is always a possibility. But of course, the indigenous peoples can have and should have a standing before specialized courts on human and people's rights. I know that the European Court of Human Rights and the Inter-American Court of Human Rights have not been conceived originally as courts dealing with people's rights, but the African Court of Human Rights is a court which was conceived from the very beginning as a court which deals with human rights, and before which peoples actually as a collectivity, as indigenous peoples, can bring cases before the court, not only as individuals. And therefore, I hope that that trend, which has been inaugurated and started by the African Court on Human and People's Rights, will extend also to other specialized courts on human rights.
Thank you, Your Excellency. You won't let it off the hook, because there's another question for you in relation to an elaboration of your expansion of the interests of the international community beyond cultural sites to the protection of vulnerable groups, social identity and intangible heritage. The question by Aliki Gankana is whether you see this also reflective of customary international law, this movement.
I think so, because I don't think that the court can simply say that this type of rights are rights which should be recognized in international law without there being some sort of a legal grounding for them. And of course, when the court referred to these rights, both in the Bosnia case and in the Croatia-Serbia case, the court was saying that although the Convention on Genocide did not refer to the rights of vulnerable groups with respect to their cultural heritage and their language or their monuments, etc., that this is something which may be recognized under other rules of international law. And therefore, the court said this may be addressed by other norms or under other norms. And I think that the reference there was to customary international law.
Indeed. Thank you very much, Judge Youssef. Another question to you, Professor Francioni, and this is a timely question for Australia in the lead up to the meeting of the World Heritage Committee in a fortnight's time, and building on your experience in relation to the Kakadu National Park when you were chair of the World Heritage Committee. Do you believe that the World Heritage Committee should inscribe a site on the list of World Heritage endangered against the wishes of the state party?
Well, this is a very old question that was came up in 1998, and it has never been resolved unfortunately, by the committee. This is a very bad message that was given by the governing bodies of the convention. Clearly, this issue has been discussed so many times in relation to the text of the convention and the operational guidelines, but I cannot see how the committee can actually delete a site out of its own initiative when the site has lost its own outstanding universal value. And this has happened in the case, unfortunately, of the German side of Dresden, the landscape of the urban landscape of Dresden, and in another case involving Oman, and should not do that in the case instead of the precautionary measure of placing a site in the World Heritage in danger because of potential or actual dangers to the site. As of course you know, in the case of Kakadu, there was an official fact-finding mission that I had the privilege of leading that came up with a recommendation to proceed with the inscription of the site in the World Heritage in danger. But because of the political horse trading in the committee, eventually this inscription never occurred. And this is, of course, brings me to the major risk for the World Heritage Convention, that is the risk of politicization and discrediting of the whole process by introducing political considerations when we have instead legal grounds for taking a measure. This, of course, is something that it was completely lamented, complained of in the 2012 40th anniversary of the convention that took place in Kyoto. And there was a general complaint about this drifting into politicization of the system. But it seems that, of course, very little has been done to address this issue. As far as my personal opinion, that can be also found in the commentary of the convention, is that there is no ground for holding that consent of the territorial state is necessary to put a particular site in the World Heritage list in danger, because the committee has not only the right, but the duty to revise periodically the list and monitor the list. And now we have also a system of monitoring, and therefore take action consequently. So logics from the point of view of law does not match the logic from the point of view of politics in this case.
Thank you, Professor Francioni. And the next question is Professor Dora. You mentioned that this is from David Shepherd. He refers to your barriers that are built up in the convention between nature and culture. And he asks, if you were in charge of the convention, how would you break those barriers down? And should Indigenous peoples be formally integrated within the structure of the World Heritage Convention, and how?
Mm-hmm. Well, as to the first question, I think that the references that I made to the holistic worldviews of Indigenous peoples, that there should be space and a place to infuse the notion of outstanding universal values, natural values, cultural values with the perspectives of indigenous peoples. And many of them are even embraced in, for example, the preambular language of the UN Declaration on the Rights of Indigenous Peoples. And I also think it's important to say that that these norms, these standards, really emerge from the storytelling of indigenous peoples, and hence the important references in the preamble, but also in the operative paragraphs of the declaration itself. I think that if there is an assessment of the present conditions and a highlighting of the areas where adjustments could be made, clearly this would be one of them, and I think a major one. In terms of the role and place of indigenous peoples, I strongly feel, and I know it was raised 10 years ago at the occasion of the 40th anniversary of the World Heritage Convention, that indigenous peoples ought to have a space and a place within the whole process, especially and specifically where their lands, territories, and resources, as well as their livelihoods and other customs, values, and practices, are going to be impacted by a designation. Too often we have seen situations where these important dimensions of a huge segment of the human population aren't taken into account. And so I think that here again, in terms of an assessment, it would be extremely useful for indigenous advocates as well as scholars like my co-panelists here to look at what exists today against the backdrop of these important human rights standards, and ensure that there's consistency and alignment with the standards in the context of the convention. And I think that there is room for that, and hence my question at the end of the presentation is when do we begin? Because indigenous peoples have been in receipt of the short end of the stick too often in relation to nominations. I pointed out some positive developments in order to illustrate that there is a willingness, but unfortunately it's so uneven and done state by state, when in fact we need a uniform and equitably operationalized method to ensure that indigenous peoples and their status, their rights, and their role in the context of the convention and site specifically are respected.
Thank you very much, Professor Dora. I'm going to put a question to you and also to Professor Francioni from somebody that's very familiar to us all. Federico Lenzerini, Professor Lenzerini asks, as a follow-up to what you have just said, whether a solution can be had from what is occurring in relation to the 2003 Intangible Heritage Convention, which requires mandatory, it's a mandatory condition of inscription that there be consent by the relevant group. And in this case, we're talking about Indigenous peoples before an inscription occurs. Professor Francioni and then Professor Dora Dali.
Okay.
Professor Francioni?
Okay. No, if I understood correctly, the question is the impact of the 2003 Intangible Heritage Convention.
No, whether under the 2003 Intangible Heritage Convention, it requires that there be consent is mandatory prior to inscription on the list for the intangible.
But I mean, I think I was very much impressed by the intervention by Dali, because she raises the fundamental issue that really haunts the World Heritage system. The system was conceived and remains a system that is driven by experts. The experts of IUCN, the experts of ICOMOS, the expert of the Venice Charter for Restoration, the experts who are witnessing authenticity. It's the world of experts. International law is dominated by experts, by the way. You know, experts dominate the world of trade, the world of investments, and now, of course, the world of environmental law. But of course, Dali is saying we need something beyond the experts. We need the people who own, who are the inhabitants of these sites, and they are, of course, not the experts, but the protagonists of the living culture. So this is, of course, requires a change in the paradigm. And this is something that, of course, is approached gradually. I mentioned the case of East Rennell, when the customary practices of the people were accepted and put at the basis of the system of management. But it's not enough. It's not enough. Of course, what Dali says, when do we start? I don't know how to answer that, because that's the question that, of course, we need to address, all of us. We need to start at one point with another idea of what international law serves us, what is the purpose, because obviously it's also the idea of human rights that today is inadequate and is at the basis of a great deal of disenchantment that we have, but simply because we have used the human rights in the wrong way. George Yusuf was mentioning earlier that we have courts of human rights that do not deal with collective rights. They do not deal with cultural rights. The European Court of Human Rights has dealt with environmental rights only in an individual dimension, which is ridiculous. You cannot. But this
is one of the important contributions. Excuse me,
yes,
Professor Frangioni. But this is one of the important contributions of Indigenous peoples in the human rights standards process. Is that
no doubt.
We've expanded this area of human rights.
It is important. It is very important that you have your role, and that your consent is always respected and required, no doubt. Yeah. It's not only because the 2003 convention, of course, hinted to the role of communities. You know, the 2003 convention is based on the three elements of a practice that is evolving and is visible, on the community that must exist. And in the case of indigenous peoples, we have more than a community, we have peoples. And of course, the spaces that are related to this, and that is the mosaic, the territorial mosaic of culture and environmental elements that constitute then eventually the World Heritage Site. So no doubt we need to change that, but whether we can do that within the existing intergovernmental system that has allowed a certain flexibility, or we need to have new institutions and new normative instrument, that's a question that I leave open for the time being.
I quickly want to say that the adjustment is significant and important, but at the same time, there also needs to be recognition of both the substantive and procedural aspects of the right to free, prior, and informed consent. As I said in my presentation, that free, prior, and informed consent is sourced in the right of self-determination. And in order to really operationalize it, then the recognition of the substantive elements of the right plus the procedural elements of the right, there has to be accommodation of both. And procedurally, I think there's unfortunately in the present structures too much room to not necessarily tick that box off in a good faith fashion on the part of others and in particular states. The other dynamic is that these matters often take time, and Indigenous peoples and their ability to and their capacity, which is extraordinary, to take the time, often means that others don't have time. They're impatient about these matters. So I think there are all kinds of adjustments that have to be made. I just also want to comment on Francesca, your reference to experts, and indeed, I know quite a few that are of Indigenous descent. One example is the entire area of Indigenous knowledge. And in fact, in the UN Framework Convention on Climate Change, we've spent a substantial amount of time trying to increase the capacity of state party members in the area of Indigenous knowledge, of which we are the experts of. And it's been a challenge, to say the least, but what it has revealed is an opportunity to bring Indigenous peoples forward and Indigenous knowledge holders in order to reveal the best possible information about the impacts of climate change within Indigenous peoples' lands and territories, as well as others, so that we end up with an extraordinary opportunity for co-production of knowledge about a site, an area, or environmental impacts, a whole host of things. And this is just one example of the kind of expertise. And I know you're familiar with these elements, but I think it's important to note the extraordinary expertise of Indigenous peoples in a host of areas, and in part those engaged with ICOMOS and IUCN and elsewhere, there needs to be more of an embrace and welcoming of Indigenous peoples and Indigenous perspectives in order to kind of create the change that's needed. I'm not advocating necessarily the opening and renegotiation of the convention, but moreover, important procedural changes and also the openness to being responsive and respectful of the developments that we have seen in international human rights law, largely by virtue of the advocacy of Indigenous peoples themselves. So I want to be optimistic about the possibilities and make whatever positive contributions that can be made. And I don't know if the presentation that I shared offered at least some hints at what could potentially be done and taken up by Indigenous peoples as well as others. So thanks to those who've posed the questions.
And to the panelists and to the attendees, I know the time and also that there are many other questions that have been posed. Unfortunately, we can't put them all to the panelists because of time. And I'm trying to be kind to all of our panelists because they have been most generous with their time already. So what I propose to do is put one more question to each of the panelists in reverse order of their presentations. So I'd like to very quickly, and I'm taking advantage of being the chair, is putting a question to Professor Dora. The question, I think, is highlighting a number of the questions that are put by some of the attendees, is given your experience over many decades in UN fora and bodies, which you've seen Indigenous participation sometimes working well, sometimes not working well, and given that it is the 50th anniversary of the convention next year, what advice would you offer by way of which mechanisms work or which processes work to enhance participation of non-state actors, but particularly Indigenous and First Nations peoples? Darling.
Thanks, sorry. I think one of the more recent and remarkable developments has been in relation to the UN Framework Convention on Climate Change, where we now have a body that consists of both equal representation between state party members and Indigenous peoples. And in contrast to, for example, the UN Permanent Forum on Indigenous Issues or the Expert Mechanism on the Rights of Indigenous Peoples, there is no oversight in terms of the selection of Indigenous experts to serve and represent the 7 sociocultural regions that are used within the UN system. And so it's an example of the Indigenous Peoples Caucus, or what is referred to as the International Indigenous Peoples Forum on Climate Change, to select representatives that are allied directly with them and responsive to their voices, to serve within this facilitative working group capacity with states. And it has a maybe a narrowly defined mandate within the UNFCCC, but how it's structured, it is significant. It remains to be seen how effectively their engagement will result in substantial changes. I mean, we have some of the same problems with recognition of human rights and some of the instruments that are emerging out of the UNFCCC, but it at least has some elements that are useful and responsive to ensuring Indigenous peoples' direct participation on their own terms.
Thank you very much, Professor Dora. The next question, and the final question to Professor Francioni, is Professor Francioni, it's from Andrzej Jakubowski, who we know very well. Professor Jakubowski asks, considering current attempts by various states to nominate sites of recent conflict on the UNESCO World Heritage List, do you think that the enhanced participation of non-state actors in the listing process might be helpful to alleviate possible tensions and conflicting memories about sites?
So this question is addressed to me, Anna?
Yes.
Okay. No, I don't think that that will have an effect on the situation of violent extremism that leads to the destruction of cultural heritage. Not certainly in the cases we have seen recently in Mali or in Iraq or in Syria. I think that the non-state actors participating in the work of the World Heritage is possible. I think that the World Heritage Convention has shown a very high degree of flexibility toward the expansive reading of its own provisions. I mentioned in my earlier remarks the establishment of a system of monitoring on the basis of a very, skeleton of a provision, Article 29, that certainly was not designed to obtain that effect. So I think that it is possible, but of course it is not only in the hands of UNESCO or the World Heritage, in the hands of the states, that the 193 states. Now, if you look at these 193 states, a very high number of those states are states in which there is a conflict between the state itself and cultural communities that are not treated very well. And this is a problem. This is a problem all over the world. The world is full of these conflicts between the nationalist appropriation of cultural heritage and the local communities, minorities that are suffering. It's not only the macroscopic examples that we have, unfortunately, of states that persecute and bringing even their case before the International Court of Justice, like in the case of Myanmar, recently mentioned, but in many other cases, we have this use of cultural heritage and world heritage, particularly for the promotion of national identities, predetermined national identities by a ruling government. So this is the main problem, and it is linked to a gradual dynamic of democratization and of understanding of the importance of diversity of cultures as a source of rich resources also for the sustainable development. If the states will have the enlightenment to understand this, I think we will make progress. If they don't, I think UNESCO is bound to remain in the very strict conditions that we have today of a system driven by sovereignty, driven by state interests, and with the consequence of the sacrifice of the minorities, which is, of course, in the end, completely in contradiction with the idea of outstanding universal value, which is based on the representativeness of the cultures of the world, and also the cultures of minorities, the cultures of indigenous peoples particularly. And so I take the opportunity of saying that when I refer to experts before, I did not certainly want to, I referred more to the epistemology of assessment of world heritage. The assessment today is done according to schemes that reflect the rationality, the scientific approach, which is typical of the Western world, of the age of the Enlightenment that we are all very much in debt for, but it may not reflect other cultures, and particularly the cultures of the indigenous peoples who have a holistic approach to nature and culture. And so I take the words of Dali with great hope that the experts on that side will be able to balance and create an harmonious approach to the evaluation of world heritage in the future.
Thank you very much, Professor Francioni. And the final question is to His Excellency Judge Youssef, and it's from Sophie Starenberg. To what extent are the norms which you have mentioned, obligations erga omnes, sufficiently flexible to accommodate a conceptualization of the international community which goes beyond a community of states, but also reflects the interests of individuals and communities within those states? And I will add, again, taking the advantage of being the chair and also knowing that you were also, prior to your current role, the legal advisor to UNESCO, to what extent what you have been talking about in the movement within the court and the movement within international law can and should influence the work of the World Heritage Committee going forward? Thank you, Judge Youssef.
Well, thank you very much. Let me, first of all, say with regard to erga omnes obligations and, of course, corresponding erga omnes rights, that, and following up on what Professor Francioni just said, You know, I think that the issue is not an issue which concerns governments only. It also concerns lawyers and international lawyers, because I think that it relates to the interpretation of the law and to the application of the law. And if lawyers always stick to an extremely formal and strictly positivist interpretation of the law, then of course we will have this issue of government is putting forward their interests the way they see it. Because we have to see the law for what it is. The addressees of legal norms and legal rules and the beneficiaries of legal rules and legal norms are human beings. And then that it's being interpreted in order to take into account the interests and concerns of those human beings, whether they are individuals or whether they are collectivities. And that is why I think it is extremely important to recognize the work of the International Court of Justice on the right to self-determination and on collective rights in general. When people talk about the International Court of Justice and human rights, they always refer to a couple of cases in which individual rights were taken up by the court, but they do not refer to the groundbreaking work that the court has done with respect to collective rights and to the recognition of collective rights in customary international law. So that is the first general comment I wanted to make. And I think that one has to see the erga omnes obligations and rights through that prism and through that perspective. Because the rights and obligations which are owed to the international community as a whole, they are not owed only to states, they are owed also to peoples, you know, and therefore one has to take that into account. With respect to your question regarding cultural heritage, as I said in my intervention, whenever the court or whenever issues which actually relate to people's rights or to cultural rights are brought before the International Court of Justice, the court, in addition to the settlement of the dispute between states, tries to bring about an advancement of the law, tries to contribute to the progressive development of the law. And that is why, for example, in the case that was mentioned by Professor Frangioni, the case concerning Costa Rica, Nicaragua, the court actually spoke about environmental issues and natural heritage and the way in which it should be protected. But even in the case of Niger, Burkina Faso, which is not very often mentioned, the court also referred to the nomadic peoples and the interests and concerns of nomads, because it was a case about territorial sovereignty. And the court was concerned that in discussing territory, the concerns and interests of human beings who actually inhabit that territory and who sometimes due to transhumance have to move from one part of that territory to the other without paying too much attention to boundaries erected by states on that territory. Had to be taken into account. And this is an extremely important consideration. So I believe that if in the future issues of cultural heritage or even issues of sovereignty are raised before the court, if there are elements which concern human beings and the interests of people ensure a progressive development of the law in that respect. Thank you.
Thank you, Judge Youssef. Unfortunately, because of time, and we've already extended well beyond what was our intended time, we haven't had a chance to answer or address all of the very important questions that have been raised by a number of the participants, and I apologise for that. But hopefully it has been a rich discussion for all, and thank you to all three of our panellists, His Excellency Judge Youssef, Professors Francione and Dora, for the rich and thoughtful discussion of our themes today, and the need to effectively address participation as a human right and its realisation in the mandate of the World Heritage Committee and the work of the Secretariat and UNESCO more generally. The importance and urgency of this reform effort has been made clear by our discussions throughout our webinar series. The link to this video will be provided to all attendees in coming days. Thank you to all for joining us.
Thank you, Anna.
Bye-bye. Thank you.
And thank you to